Conservator. This is a conservator. This is a person who's been appointed by a circuit court who is responsible for managing estate and financial affairs of an incapacitated person. Okay, so think the corollary to conservator is an agent under a power of attorney. Okay. Guardian, this is a person appointed by a circuit court who is responsible for making decisions about an individual's person, their health, their care, their safety, their support, where they live, their education, their therapeutic treatment. They're responsible for making all of those decisions. Okay. And the corollary for that would be an agent under an advanced medical directive. All right. So, who can file a petition for guardianship and what does it have to include? I am intentionally violating the first rule of slide making by including too many words on one page. Okay, this is to drive home a point that we have to include a lot of information for the court. They want to know. It's not just check a couple boxes and you're going to be appointed guardian of an adult. The court takes it very seriously and wants to know lots of information so they know that the person does in fact need a guardian and that the proposed guardian is in fact appropriate. Okay. So I do want to drive home a couple of bullets here. So the first is the second bullet, court jurisdiction. So where do these get filed? These typically get filed where the individual resides. So if that's in Fairfax County, it's going to get filed in the Fairfax Circuit Court. If that person lives in Loudoun County, generally it's going to be filed in the Loudoun Circuit Court. Okay. The other bullet I want to address on this slide is the third bullet, the one right below that. We have to include the names and post office addresses of the individual's spouse, if any, adult children, if any, parents, and adult siblings. Okay, and I bring this up because oftentimes people, whether one of the parents, whoever is going to be petitioning for guardianship, they might say, well, other parent hasn't been involved in 15 years. Do I really have to include them? If their parental rights haven't been terminated, then yes, we are supposed to include that person's name and address and eventually mail them a copy of the notice packet. Same thing with siblings, right? If there are half siblings from an uninvolved parent, technically we're supposed to include them in the process and give them notice of the hearing. Okay. A continuation of this slide, again, to drive home the point that we have to include so much information for the court. They really want to know about the individual. They want to know what kind of services is that person receiving? How is their health being managed now? Ones that I want to drive home on this point is the second one. So we have to include description of services being provided, right? And where appropriate, recommendation as to living arrangements. This can be as simple as the individual has an IEP under which they're receiving occupational therapy and speech therapy and recommendation for living, they should continue living at home. It can also be much more complex. Maybe the person needs residential services provided or they need hospitalization at a mental health facility. So it can get a bit complex depending on the needs of the individual. All right, again, driving home the point, we have to include lots of information from the court. It's a lot of paperwork, and we try to do it as efficiently as possible. All right, so we've got all that information together. What else does the court want? The court wants a medical evaluation report. Okay, this is a report that is going to evaluate the condition of the individual, right? It's filed under seal, so the only people with access to it are the court, the guardian ad litem, who we'll talk about in a bit, and anybody else that becomes a party to the matter, okay? The report should be prepared by a licensed physician or psychologist, or, and here's a catch-all where a lot of licensed professionals fall, licensed professionals skilled in the assessment and treatment of the condition as alleged in the petition. Okay, so if your child primarily sees an NP or a PA, that's great. Have that person fill out the evaluation report. I've also had LCSWs fill out the evaluation report. That LCSW knew the individual the best, and so she completed it, and she fell into the licensed professional skilled in the assessment category. All right, the report is supposed to evaluate and provide a description of the nature and type of the incapacity, including any specific functional impairments, to include a diagnosis of the mental and physical, an LCSW, good question, licensed clinical social worker. Um, the date or the dates upon examination or the evaluations and assessment, and then the person needs to sign the evaluation so the court knows that he or she filled it out. All right. That gets filed along with the initial petition with all that information that I just talked about or bulleted on the first or the previous two slides. All right. So we've gotten our petition and our medical evaluation together, along with a few other documents, and we've gotten them filed. Okay, as I mentioned, usually it's going to get filed where the individual resides. So if this is, filed in Fairfax Circuit Court, they're going to give us a case number and they're going to assign us a guardian ad litem. That guardian ad litem's job is to investigate the petition and essentially serve as the eyes and the ears for the court, right? So he or she comes and visits with the individual, puts together a detailed report for the court, and then is, giving the court a recommendation as to what the guardian ad litem thinks is in the individual's best interest. Okay, so we got the case number, we've got our guardian ad litem assigned. Now we have to set a hearing date. And different courts do these at different times. For example, Fairfax Circuit Court does these every morning, every Friday at 9 a.m. Loudoun is like the first, third, and fourth Friday of the month at 9 a.m. In Norfolk, it's any morning at 9, 9:30, or 10 a.m. You pick a time that works for everybody and you submit a notice and you have your hearing. Other courts around Central Virginia, you get a specific time. So you reach out to the judicial assistant and they'll say, I've got, these 4 dates. Do any of them work for you? So it really can vary depending on which court we're in. Okay, we get the hearing date set. And then once we've got the hearing date set, we have to mail out a notice. And the notice has to say what's going on, what's happening, right? So the notice might say, let me look at my calendar. On Friday, July 10th at 9 a.m., John Doe is going to ask to be appointed guardian of Jane Doe at the Fairfax Circuit Court. And then it's going to list a bunch of rights that the individual has. It's going to also include some warnings to others, how you become a party to the action, and a copy of that notice and the petition gets mailed to all adult individuals listed in the petition. Okay, so remember, I talked a couple slides ago about it's important to include parents and adult siblings, even if they haven't been involved, and they get a copy of the notice mailed to them. Okay. The notice also includes, as I touched on just a second ago, warnings for the individual. The individual has certain rights during the process. They have the right to, their own attorney if they want one. They have the right to put on their own witnesses if they want one. They have the right to a jury trial if they would like to have one. Typically doesn't get invoked, but they have those rights should they want to exercise them. And second bullet, the individual, the respondent, has to be personally served with a copy of that. So when the guardian ad litem comes and visits with the individual, they give them a copy of the packet. They say, here's a notice. Your mom and dad are asking to be appointed guardians for you. And they advise them of all the rights and talk with them about the process and any questions they have. All right. Will we be able to get a copy of this? Yes, we can send that out. All right, so we filed it, we got our case number, our guardian ad litem, we set our hearing date and mailed out the notice, then we have the hearing. What happens at the hearing? So it kind of can diverge in 2 ways. If it's uncontested, the hearing can be fairly efficient and fairly quick. And so usually the court has already reviewed the petition, the medical evaluation, and the guardian ad litem's report. And sometimes, depending on which court we're in, the court has already reviewed the proposed order that we're going to bring with us to the hearing. Okay? And so at the hearing, the court is supposed to determine whether the individual is in need of a guardian and or conservator. And then the court appoints what's called a suitable person. Generally, that's the person asking for a guardian or conservator to be appointed, although not always. Okay, and the court is supposed to inform the guardian or conservator about his duties. All right, and so the last couple bullets there, so they're supposed to the extent feasible, encourage the individual to participate in decisions and to act on his or her own behalf, and to develop or maintain any capacity for managing personal affairs that that individual has. All right, in the court's order of appointment, a few bullets on the next slide I'll read through, but I want to note that a guardian, and we talked about an advanced medical directive and a power of attorney. Why are those important? Those are really important for us as parents as well, because a guardian need not be appointed for a person who has an agent under an advanced directive, and a conservator need not be appointed for a person who has an agent under a power of attorney unless certain findings are made. And so, as parents, we want to make sure we have these documents in place so that our children or our own siblings don't have to go through this guardianship or conservatorship process for us. Right? So, our own estate planning is very important. All right. Additionally, and this one I think is more relevant to what we're talking about today, a conservator, looking at bullet number 2, need not be appointed for a person, and then now little 2, whose only or major source of income is from the Social Security Administration or other government program, and who has a representative payee. So typically, if the individual's sole or primary source of income is going to come from Social Security, such as SSI or SSDI, those funds get managed under a representative payee system and not as a conservator. Okay? All orders appointing a guardian have to include this conspicuous, bold, 14-point type language here. Okay? And I want to highlight two of them, although obviously the whole thing is important or it wouldn't be required in all guardianship orders. Bullet number 2 says a guardian, to the extent possible, shall encourage the incapacitated person to participate in decisions, shall consider the expressed desires and personal values of the incapacitated person to the extent known, and shall not restrict an incapacitated person's ability to communicate with, visit, or interact with other persons with whom the incapacitated person has an established relationship. And there's a little caveat, if it's going to be harmful to them physically, mentally, or emotional, then you can go through a process to restrict somebody's ability to visit with or interact with them. But absent that, you shouldn't unreasonably restrict that ability. Okay, the third has the annual report that we talked about, but then I also want to highlight number 4 because it'll come up again when I talk about common misconceptions. I often hear that, oh, guardianship's in place, like that's never going to change. And while usually it doesn't because, the level of capacity doesn't change, it could. I've terminated a number of guardianships where a person has regained capacity to make decisions for themselves. But bullet number 4, it says pursuant to Code Section 64.2-2012 of the Code of Virginia, all guardianship orders are subject to petition for restoration, modification, or termination. Okay, so they are. If circumstances change and the individual regains the capacity to make appropriate decisions for their own health care or safety, we usually get an updated medical evaluation that we talked about before. It says they have the capacity to make appropriate decisions for themselves. We file a termination petition. Again, similar process, guardian ad litem gets appointed, comes and visits and says, yeah, this person can make his or her own decisions. We should terminate this. All right. You don't see it that often because circumstances don't usually change that much, but it is possible. All right. A little bit about the timeline. This is always a question that I get. When should I reach out to an attorney? When should I start the process? I like to tell parents, reach out anytime when your child is 16 and a half or older. Okay. So that gives plenty of time for me to send intake documents to the parent or whomever is going to be petitioning for guardian, for them to get them completed, right? Remembering one of those forms is a medical evaluation. So depending on your child's healthcare provider, that might take longer. It might be quicker. I've had one provider complete it in 30 minutes. It was a record. I've also had one take 4 months. So it takes time to get those completed. So allowing extra buffer time is never a bad idea. Okay. So usually I say reach out between 16 and a half and 17. If your child's already 19 or 20, it's not the end of the world. But, feel free to reach out and get the process started. All right. So we got that. I have those intake documents. I've collected those. This can be filed if it's being filed by the parent or the guardian at 17 and a half. Okay. So that allows plenty of time for the process to be completed and there be no gaps in decision-making authority, right? And let me take a step back. This whole thing is needed or is in place because the law presumes that when an individual turns 18, he or she is his or her own guardian, period. Okay. When I turned 18, I didn't have to listen to my parents anymore. Same with pretty much everybody on this call, right? So unless somebody has been appointed as another's guardian or as an agent under a power of attorney or advance directive, no one else can make decisions for that person, and only that person is his or her own guardian. Okay? So that's the kind of baseline presumption. Now, as the parent or guardian, when we bring this at 17 and a half, it can be completed before that individual turns 18, and then there are no gaps in decision-making authority for the parent or guardian. Okay? So I talked about a few things. So I break this up into actually 4 steps. The fourth will be on the next slide. But the first is that initial filing. So I talked about that. So there are a number of documents that we as attorneys have to draft and provide to the court. And the main ones are that second line there, the petition and the medical evaluation report. All right, those are critical for the court. All right, the court, once it gets filed, usually takes about a week to process it and appoint a guardian ad litem. At that point, we will have our case number and can move forward with scheduling, whether that's putting it on a Friday motions docket, contacting a judicial assistant and getting available dates. We have to make sure we have a date that works for the attorney, for the guardian ad litem, as well as for the client, right? For the parent or person becoming appointed guardian. All right, we get that set. It's usually set about 4 to 6 weeks out from once it's processed by the court. So if you're doing math, that means the process usually takes about 6 to 8 weeks. Although it can take longer, there can be hiccups. It can be shorter if it's an emergency and we can get people moving and get people on board and have a date that works for everybody. But that's a pretty fair approximation. Okay. Second step, we get that notice mailed out. We've got the hearing set. Now we're mailing out the notice at least 10 days before the hearing. The notice and the petition must be sent via first class mail to all of those people listed in the petition, all those relatives, and actually to the individual's primary healthcare provider. Okay. And we also email it to the guardian ad litem so the guardian ad litem can go and personally serve and meet with the respondent. Okay, then we have the hearing. Okay, between those 2 steps, the guardian ad litem is putting her report together and getting it to the attorney and to the court. And then the attorney should be drafting the final order. So this is the order that's going to be presented to the court, that's going to be signed by the attorney, by the guardian ad litem, presented to the court for the judge to endorse and enter as well. Okay, and that's going to lay out everything that the guardian can do, everything that they have to do, and really give people an idea of what does this person have to do as guardian? What can they do as guardian? Okay, at the hearing, which again, the code says is supposed to take place within 120 days of the filing. Generally, that's closer to 6 to 8 weeks. I guess it's at 4 to 8 weeks on the slide. We're going to present the court with a certificate of compliance. So I'm going to say I complied with all of the code sections required. We have to provide certifications of proposed guardian. And then the real critical document is that final order that lays out everything that the guardian has to do and all of their authority. Okay, at the hearing, usually, if they're uncontested, they're fairly quick. They might take 5 or 10 minutes, depending on where you are. The judge might say, hey, I've reviewed the pleadings. I've reviewed the guardian ad litem's report. Everything appears to be in order. Does anybody have anything they need to add? And usually when a judge says that, you say, no, judge. And the guardian ad litem says the same, and they usually say, do you have an order? You hand it up, and the and the judge signs it. Okay. Then what's next? After the judge signs it, the guardians have to what we call qualify. So usually what that means is we walk you down to the probate office of the circuit court and they give you certified copies of everything. And the clerk has you sign an oath. And the oath essentially says, I'm going to faithfully uphold my duties as guardian. Okay. Um, And then lastly, so once you're appointed, you're going to get certified copies of everything. You're going to give your oath, and then you should leave that day with everything you need to continue assisting with decision making even after an individual is 18. All right, I want to highlight a few common misconceptions that I hear pretty regularly, but want to address. And then if there are questions, I will try to hit as many of them as I can. The first one that I hear all the time is I am taking away all of my child's rights. Okay. And I usually respond with, well, what rights are you taking away? And I'm not trying to be coy when I ask that, but I try to say, well, what rights is this person going to use that they're going to lose in this process? Um, Many are probably aware here, but that as of July 1, retaining the right to vote is going to be pretty scrutinized and regular practice, even in guardianships. Retaining the right to drive also can be accomplished again depending on the person's capacity. And so, in addition to voting and driving, the three main rights that I see implicated usually are the right to own or possess a firearm, which most people are like, that's fine, you can take that away. The second is the right to get married without the consent of the guardian, right? Again, that's probably a good thing, right? As many are aware, public benefits law is pretty complex. Sometimes getting married can be detrimental to one's benefits. And so having a guardian who can say, yeah, that's a good idea, or yes, that's appropriate, helps to prevent a child or a young adult from being taken advantage of. And the third, so we've got voting, driving, firearms, marriage, and then enter into a contract, right? So the individual loses the ability to enter into a contract, which is generally a good thing, right? While we as parents are looking out for the best interest of our children, sometimes the rest of the world isn't. Right? Sometimes people might look to take advantage of our children, right? And we as parents, as guardians, can be there to protect our children and make sure that people don't do that, right? For example, maybe your child just turned 18 and they get a credit card, letter in the mail. And they're like, oh, this seems cool. And they fill it out and they send it in and they spend, $1,500 on a credit card. Well, if they didn't have a guardian in place, they could do that. And that might be a bad idea because they don't have the $1,500 to pay back that debt. Okay, bullet number two. I was told by my child's case manager to start the process when he turns 15. Um, I'm glad that the case managers and your teachers are on top of this. That's great. I can't tell you how many people call me and they're like, my kid turns 18 next week and I just heard about this guardianship thing. Not the end of the world, but I understand the rush and the pressure to feel that. 15 is a little early, like I mentioned. 16 and a half to 17 is a good sweet spot. Even 17 to 17 and a half gives plenty of time to get things finished. Third bullet, guardianship will fix all of my child's behavioral and mental health needs. While it does give the parent authority to make decisions, it doesn't necessarily change behavior, right? My child's school and care providers will continue communicating with me even after he turns 18? Maybe, maybe not. So it's helpful to get this in place so that there are no gaps in your communication and decision-making abilities. All right. The state will come take away my child if I don't have guardianship of him at 18. I'll also say pretty untrue. Usually, if you're thinking about like adult protective services, they're usually looking for like elderly individuals who are living on their own and probably shouldn't be. They're not looking for, parent or children of parents who the kids just turned 18. Um, the other one I hear pretty frequently, I'm just going to do power of attorney. And while power of attorney may be the right avenue to have a decision maker for your child, it may not be. And so, understanding why power of attorney would be appropriate and helpful and why it might not be is important. I'm already my adult child's guardian just by virtue of being his parent. This is all not true. This is also not true. Again, we start from the threshold that I mentioned. At 18, everybody is their own guardian. Okay. I've had a person with a 50-year-old child. They're like, wait a second, I can't make decisions for my child? No. All right. Aren't guardianships impossible to terminate? I mentioned that all of them are terminable, modifiable. It just depends upon the circumstances and the change from the original entry. I can already make medical and financial decisions for my child, even though he is an adult. No, if your child's already an adult, he makes his own decisions. And lastly, I was quoted $7,500 by an attorney for the whole process. That would be quite expensive, unless it were very contested, right? And there are two ways generally that a guardianship can be contested. One is if the person's capacity is contested, right? Usually we don't see that with people turning 18. We see that like end of life, right? Think Alzheimer's or dementia, right? A person who's taking care of themselves their whole life and then maybe their child comes in and says, hey, I need to be appointed mom's guardian. She's living alone. She's fallen 10 times in the last 6 months. She's been hospitalized. Like she can't make her own decisions clearly. And mom might say, what do you mean? I can make all my own decisions. So question her capacity, right? So that's one way it can be contested. The second is who is appointed as guardian. Sometimes you see this with children, right? If daughter is asking to be guardian of mom, son's like, well, no, 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 you shouldn't be guardian. You're terrible. Like I need to do this. Or you might see mom versus dad, right? One of them's like, hey, I should be guardian of our soon to be 18-year-old son. And the other's like, well, heck no, you shouldn't. So you see that, in which case, maybe that is an appropriate figure. But in an uncontested scenario, that is way too high. And, reach out to me. I'd be happy to help you for way less than that. All right. And that's it. If anyone has any questions, please feel free to post them in the chat. All right, I'm gonna work through them as I see them here. So I already answered what's an LCSW, licensed clinical social worker, very critical. Uh, I will send out a copy of the presentation. All right, let's see. My son just turned 18 and I've been trying to get certain information for the past year, but haven't been able to get it. He currently needs me as his guardians. One of the things that I was struggling with was knowing how to start the process and whether we could find an attorney that can help us pro bono. So a couple of things. So depending on where you reside, there are legal services providers who can connect you with pro bono attorneys. You can, so if you're in Northern Virginia, that's Legal Services of Northern Virginia. They used to do guardianship matters in-house, but I don't believe they do anymore. You can also, if you want, reach out to me. I'm happy to get you some information. And I do help a number of families throughout the Commonwealth on a pro bono basis each year. So to the extent that you need that, I'm happy to be a resource for you. So feel free to reach out. All right. If everyone involved resides together other than the medical provider and the guardian ad litem, does the filing still need to be mailed first class? Is that superfluous or does that still need to be done for the record? Yes, the code says it needs to be mailed via first class mail to all of the relatives that we list. So usually that means I'm mailing a copy to, maybe it's mom, dad, and adult sister who live in the same home. They're all going to get a copy. Because I, as the attorney, have to then certify that I mailed a copy to all adult relatives listed in the petition. So to make sure everything is complete, I do still mail it first class mail to all of the adult relatives. All right. All right. Okay. All right. She got that one. All right. I've heard about limited guardianships. Can you touch on that? Yes. So we can have limited guardianships or limited conservatorships. And I'll give an example of each. right? So a limited conservatorship might be needed. Let's say mom did her power of attorney and her advance medical directive, but in her power of attorney, she did not give her agent the authority to sell her house. Okay, she didn't want her agent to have that authority. Okay, mom subsequently got dementia, Alzheimer's, and needed to move into memory care. Okay, as I'm hopeful many people know, that is very expensive. And so, in order to continue to pay for mom to be in memory care, the agent had to then become appointed limited conservator for the purposes of selling mom's house and using those proceeds to pay for her stay. Okay. Mom had done her advanced medical directive, so she didn't need a guardian. She just needed a limited conservator. And she had already done her power of attorney, so she didn't need a full conservator. She just needed a limited conservator. Limited guardianships. I often see these in the mental health context. Okay. We might have an example, might be let's say an individual has paranoid schizophrenia. Okay. And while on, quarterly injectable medication, that individual functions at a baseline of functional, right? Has a job, lives independently, does all of the things that adults do. However, when that individual gets to the point where he or she thinks that, hey, I don't need this injectable anymore and stops taking their injectable, everything drops off the deep end, they get hospitalized consistently, etc. You might have a limited guardian appointed for the purpose of medication management, right? To ensure that that individual is taking their, in my example, quarterly injectable as prescribed by their providers. Sometimes people refer to guardianships as limited if an individual is retaining rights, like to vote or to drive, maybe to make a will. So sometimes that can be referred to also as a limited guardianship. All right. What do you think is a reasonable price for a normal process of guardianship? Um, I'm going to guess that most people on this call are in Fairfax County. I would say the average cost is probably 3,500. Now, there are people like me, and I know a couple other attorneys who try to consider everybody's circumstances, right? So if you're on public benefits, it shouldn't cost that much at all. But that's probably average reasonable cost. Part of it too is it really depends on how much time it's going to take for the attorney, right? So you may or may not know our lives are pretty much in point one, tenths of an hour, right? Because we bill everything point one, right? If I, worked on a contract for 35 minutes, point six, I got to put it on a bill. And then ultimately that gets sent out to the client. So part of it depends on how much time it's going to take the person. I do a lot of these a year, and so I'm fairly efficient at it. And so I like to think that I can, have a low cost for people to try to give them, as much of a benefit as I can. But I would say the average cost, if you just called up, five law, like if you Googled, attorney, Fairfax County guardianship, you call five of them, my guess is your average cost there would probably come out to 3,500. All right, two questions. The two main reasons I encounter from parents who are hesitant to become guardians are one, the inability to pay, and two, fear of financially becoming financially liable or having their assets included in a Medicaid clawback. Can you speak to if the guardian's assets are included in clawback laws or if guardians can be held financially responsible for unpaid medical bills? All right, so guardians are not personally liable for their ward's actions or their debts unless the guardian is personally negligent. Okay? So if your child's in a group home and, punches somebody else in the face and incurs, liability for doing that, you weren't negligent. You didn't do anything. If your child had his or her driver's permission taken away and you handed them the keys to your car and said, go have fun, and they got in a car accident, that's that's negligent. The court's going to hold you liable for that. Okay. But, absent negligence, a guardian is not liable for the debts or for the actions of their ward. Likewise, guardians' assets are not included in clawback provisions for Medicaid, right? So if your child received, $1 million in benefits from Medicaid over his or her life, the only thing they can look at is that child's assets in order to try to recover from that. Usually, they were just receiving SSI, so there's nothing for them to recover. Resources for families to pay for guardianship. Yes, good question. Um, Contact me. I'd be happy to help you. Second, contact your local legal services organization. So if you live in Central Virginia, that's the Central Virginia Legal Aid Society. Another good one in Central Virginia, there is Hunton Andrews Kurth has a pro bono office. It's in Church Hill. So that's another one to contact again, Central Virginia. If you're in the Tidewater area, that's LACEVA, Legal Aid Society of Eastern Virginia. If you are in the western part of the state, that is Blue Ridge Legal Services. And then if you are in the northern part of the state, you might contact, well, one, talk to your school's transition coordinators. Two, you might contact your local ARC. I guess that's for the whole Commonwealth. You could contact your local ARC. So I know ARC of Northern Virginia and ARC of Loudoun have some great resources. And then your legal service provider there is Legal Services of Northern Virginia. Um, I I know they don't do guardianships anymore. I don't know what they're doing if people reach out to them and need that help. But you can also feel free. I think my screen is still showing here. I'll pull the slide up. You feel free to give me a call, shoot me an email, and I'd be happy to either help you or connect you with somebody that can. All right. Is this something you can put in place as a backup in case you need it and your can't make child make decisions otherwise? I think they may be meant to say your child can't make decisions otherwise. So yes and no. If your child is in a place to make decisions, then it might be helpful to get an advance directive and a power of attorney in place so that if he or she gets to the point where he or she can't make decisions for themselves, you can step in. If they're at a position where they already can't make appropriate decisions for themselves, a couple things. It can be helpful to become their guardian one because you already can have the decision-making authority you need. Likewise, it doesn't mean that they can't make decisions, right? As I read in that big bolded language that we have to include in orders, you're supposed to encourage them to make decisions, right? If your child can make appropriate decisions for how they want to dress or what food they want to eat or where they want to live, by all means, let them make those decisions, and you're encouraged to let them make those decisions. But having the guardianship in place can help to provide guardrails so that you can protect your child from bad decisions or hopefully from bad actors. Likewise, I've mentioned this. You mentioned backup, right? A lot of times, parents, a main concern for parents is, well, what happens when I'm gone? Right? That you're trying to plan for two lifetimes, your own and your child with special needs. And part of that is if you go through the guardianship process, you can kind of plan for that by one, there's kind of two main ways. The first is to name what we call a standby guardian, right? This is a guardian who's going to take over when the guardian is not able to, whether he died or he is incapacitated himself, right? So sometimes it's common to, let's say, mom and dad be appointed as co-guardians for their child and then have their other adult child appointed as a standby guardian. So that when mom and dad pass away, other, I guess, adult sibling to the person can step in as the guardian. Okay. The other way that we can kind of plan for this without any additional need for court involvement is to go ahead and have that person who's going to take over appointed as a co-guardian, right? That would mean that that person has present authority to make decisions, with and for the individual. But it also means, right, in my hypothetical, maybe you have mom, dad, and their other adult child appointed, all three as co-guardians. And then when mom and dad pass away, other adult child just keeps acting as guardian and doesn't have to do anything different except be the sole decision maker and not make decisions with other people. All right. Question. So guardianship and conservatorship are separate things. Yes. We separate them out here in Virginia. Guardianship, conservatorship. Some states might call it guardianship of the person, guardianship of the state. Estate, some might call it conservatorship of the person and conservatorship of the estate, but we separate guardianship, conservatorship, healthcare, safety, finances. All right, and conservatorship isn't necessary if respondent's income is primarily or only Social Security. Yes, but is it useful to apply for both anyway, rather than maybe have to go back and later apply for conservatorship? I would imagine it's a lot easier and cheaper to apply for both at the same time. Good question. So, yes and no. Um, I typically, if the person is only going to be receiving Social Security, have the parents appointed or whomever appointed as guardian only and no conservator. Part of that is, I think it's upfront more cost effective to just become guardian, right? Because even though conservatorship is part of the same process, that also adds a couple of extra layers to the drafting and to everything that goes, into the guardianship process as a whole. So that can take more time, which usually means more expense. Additionally, as conservators, you have accounting responsibilities. And so that can be just another, time involved process for already time strained parents. And so, in that respect, I typically don't have them appointed as conservator. Now, a reason why you might want to be appointed as your child's conservator, maybe he or she is got injured in an accident and is going to receive a large sum of money as a settlement. Then yes, it would make sense to be the conservator because you need to be able to manage those funds. Um, Arguably, if the person is working and their income from work is going to exceed Social Security, then you should become their conservator. I will note that, though, sometimes banks, if there's already a representative payee in place, will allow guardians to kind of manage work funds along with with Social Security funds. And so, in that respect, sometimes it's easier to, as I say, let sleeping dogs lie and just let it be. Um, so yeah. I mean, it's not wrong to do it one way or the other. And you might talk to an attorney who says, oh, become their guardian and conservator. You know, if you want to, you can. But likewise, is there a need? Do you need those additional requirements and that additional upfront expense? I've helped people later become conservators. It doesn't really involve that much more cost. And if anything, it's a deferred cost. So I typically don't do guardianships and conservatorships again when it's only going to be Social Security. All right. Many things to consider as I see and aim to use the best fit or least restrictive option. Yes, that's correct. Is there an easy flow chart that shows how to step through this, if this, then this, for consideration of using a power of attorney versus an advanced medical directive and guardian conservator? If you go to, what's the resource? Mm, I think it's on the ARC's main page. So the ARC is very, they love the use of what's called supportive decision making, right? So that's a very, it formalizes kind of informal relationships, but also provides kind of instructions to the individual, right? So you might say supported decision making is the least restrictive, advanced medical directive, power of attorney, more restrictive, and then most restrictive, guardianship and conservatorship, if you're thinking of a flow chart. As to like when it's appropriate, so guardianships can be put in place if they're needed because the person is subject to neglect, exploitation, or abuse. Okay. So I usually think through this in my head. What would happen to the person if their current guardian, we'll say mom, dad, both, died tomorrow? What would happen? Right? If it's, brother will come and help that person live, great. If it's, I have no clue, they can't, pour their own bowl of cereal and milk, you know, that can start to become part of the consideration. A lot of times, what I'll do, if it's, if the person questions, hey, they might have the capacity for power of attorney or advanced medical directive. I just don't know. There are a couple things. One, usually I'll send that medical evaluation to the parent to have the healthcare provider complete, because then I can have a trained professionals kind of outlay of what they think is the person's capability levels. And then if I'm still unsure, I can meet with the person and say, hey, I'm, and engage from that perspective. Again, that kind of really falls to like, what is their capacity level for these documents for this process? All right. Is a medical evaluation report acceptable if it comes from a school psychologist? As long as that psychologist is skilled in the assessment of the condition as alleged, which I would assume the psychologist is. All right. Can you appoint a guardian if siblings are not willing when the parents die? Yeah, so there are lots of options for guardians. Obviously the hope is that a suitable family member does it, but sometimes people have one child or they don't have siblings who are willing to take over. You can look to other relatives, so you can look to aunts, uncles, cousins, nieces, nephews, whomever. There are also I have helped a number of sponsored residential providers who essentially they become like part of that person's family, and they care for them and they provide for them and they do everything with them. So that's an option. There are also private entities who serve as guardian for individuals, and so maybe mom and dad are appointed now, and then as they age 10, 15, 20 years from now, maybe they look to one of those private entities to serve as the guardian, right? And it's important to distinguish guardian from caregiver. Sometimes they're one and the same, right? So if mom and dad are living at home with their child, they're one and the same. Like they're making decisions and they're providing the care, but they don't have to be. Maybe the child lives in a group home or sponsored residential setting, and the group home or sponsored residence is providing the daily care, but ultimately the decision makers are the guardian. Maybe mom, maybe dad, maybe both. So it's important to distinguish those. What should we do about our just turned 18-old who needs guardianship when it comes to the selective service paperwork? Um, I don't have that paperwork, but what I've heard other people do is just mark through it. And I think there's a box where you can provide comments. You can put, severely disabled and put the diagnoses and send it back. They'll get the picture. Is that even for a kid over 18? Yes. Guardianships are for any age, right? You can, maybe your kid already turned 18 but needs a guardian and you just heard about it. Maybe I see it in like a midlife crisis. Maybe your brother was in a motorcycle accident and is in a persistent vegetative state and never did his estate planning. So somebody has to go through the guardianship process to make decisions for him. Or maybe your mom has Alzheimer's or dementia and never did her planning, and you have to go through the process for them. So guardianship can be started at any age. All right. Uh, Getting through them. If I already have guardianship in place, can we add a co-guardian later? Yes, that would be part of the modification. So that would be a modification to the guardianship. You could add a co-guardian, substitute somebody in for you. Definitely have done both of those. Okay. What happens to guardianship if you later move out of state or the backup guardian is in another state? Do you have to file in that state at that time? So, couple things. If you're moving permanently out of Virginia and you're the guardian, you need to get permission to do that and transfer it to your new state. If it's not permanent, maybe it's for military orders that are only for 2 years and you might come back. Again, kind of fall back on my let sleeping dogs lie. Um, the backup guardian is in another state. That's perfectly fine. All right. I know it's one that people have to drop. Feel free to. I'll keep answering questions. All
What I
right.
was going to ask. Thank you.
Yeah. Do you find that the child is resistant to cooperating with parents to secure guardianship? It is for all intents and purposes they are capable at the time as to fall back since the process is so long. No, not necessarily. Um, just because somebody resists guardianship doesn't mean that they need it, right? So I think of the, old woman with severe dementia, right? She might think she doesn't need a guardian, but she probably does if, certain criteria are met, right? Likewise, you could have, let's say, somebody with autism who is very high functioning, right? But they are engaging in like risky behavior, right? An example I'll give is a young girl turning 18 and indicating to her parents that she's going to make all her own decisions. They're not to be part of her life anymore, and decides to get on dating websites. And can't understand why, when she meets up with older men, they have expectations that she doesn't know about. Nobody's there to protect her. Parents come in, become appointed her guardians over her objection, kind of shut down those like dating apps, get her into a sponsored residential setting, and she's doing great. And her relationships with a parent is ever better. So it happens. It doesn't have to take a long time, but it can if they're going to contest. It can take longer than that 6 to 8 weeks. All right. How does Able Now funds get counted? Are they assets for the individual? Not sure what you mean about are they assets for the individual. They don't count against them up to $100,000 for purposes of Social Security, and for determination of like resources for guardianship, if that's what you mean. Okay, perfect. You got it. The continuum of decision making was posted in the chat. Awesome. So for the person who had that question or for any others, please check that out. And actually, you know what? I can probably just pull it up. Let's see if that works. Yes. It was DBHDS. That's what I was trying to think of. All right. So DBHDS has
You
this
can
link.
scroll down a little bit and you'll see the chart.
Oh, there you go. All right, perfect. So there's your chart. It seems like they have when, how questions on there. Haven't really vetted through those, but I know DBHDS is a great resource to tap into. So definitely consult with that. All right, can one parent get guardianship without the consent of the other parent? Yes, it happens. They do need to notice the other parent, right? And I'm guessing if you're asking this question, that probably means the other parent would challenge your appointment. And so, again, kind of how that usually plays out is, the one parent petitions for guardianship, sets the hearing, sends out the notice. Well, the guardian ad litem's job of investigating the petition is to call the other parent and get in touch with the other parent, and they're going to get a copy of the notice. And I mean, they can do a few things with it. I mean, I've seen where the other parent's like, I don't care, puts it in the trash. I've seen where other parent just shows up and is like, hey, this is crazy. Like, they should appoint me too. Really depends on your judge about what the judge does with that. Some judges might say, well, did you file anything? And they'll say no. I'll say, okay, I'm going to appoint the parent that petitioned. I've also had that happen. And the one parent lived in Florida and hadn't seen the kid in 8 years. And the judge just looked at him and was like, where do you live, sir? And she said it. And he's like, and when was the last time you saw this person? He's like, 8 years ago. And the judge was like, get out of here. But you could also have the parent that is involved and does contest the appointment and files their own what we call cross petition and says, hey, they need a guardian, but hey, appoint me. Um, and sometimes you figure it out where both of them are appointed. Other times you have a contested hearing and the court has to decide who to appoint. Yeah. All right. 104 through all the questions. I'm happy to hang out for a couple minutes. If people have other questions. Um, I'll also put my contact info back up here to the extent you want to shoot me an email or give me a call. I'll be happy to connect. Thank you.
Thank you.
You're welcome.
Thank you.
Thank you very much.
Thank you.
Thank you. It's very helpful.
Thank you.
Thank you very much.
Thank you very much. Thank you very much. Thank you very much.
Hi, Russia. Thank you, Mr. Thompson. Thank you very
Yes, sir.
much.
Good to see you.
Thank
Hi.
you, everybody. Thank you. That was a very enlightening. Does the medical evaluation report paper, does it come from the courts or does it come from?
No, it'd come from an attorney usually.
So that means you have it?
Yeah.
Okay.
Yep.
Thank you so much.
Are we going to have copies? Sorry, are you going to have some copies of the video or transcripts?
Yes, yeah. She'll get
A recording?
yeah, she'll get the recording and I can send her the slides. And she can circulate those to
Fantastic.
folks who are here. Yeah.
And I have to admit, I do apologize. The recording started 3 slides later. I thought I was recording, but I was not. But we
Oh,
got most of the stuff.
okay.
So,
Well, I guess we'll have to do it again in the fall.
okay.
And then you can get the full recording.
Yes.
Thank you, Rasha. Nice to see you again. Thank you.
Likewise.
Thank
Thank
you,
you.
Mr. Nick.
Thank you very much.
You're welcome. Yes, you may certainly contact me for any assistance you need for estate planning or guardianship. We hit the full amount of time, so glad that Rasha had the idea not to include the estate planning portion, but do a lot of trust estates, wills, special needs trust, all that stuff. So feel free to reach out.
We can be back in the fall.
Yes. Yeah,
Hey, thank you very much.
just make it before October 17th. My wife is due.
Congratulations.
Thank you. Thank you.
Congratulations.
All right. I will end the meeting.
All right, cool. I'll email you these slides and you can disperse them as you wish.
All right. Thank you all very much.
Yep. Thank you.
Thank you, Rasha. Thank you, Ms. Cousins.
Mhm.